Colorado's approach to rent increases has undergone dramatic changes in recent years, transforming the state from a firmly landlord-friendly jurisdiction into one with significantly more tenant protections and procedural requirements. If you manage rental property in Colorado, staying current on these changes is essential, because the rules you may have followed 5 years ago have been substantially rewritten. The governing law is found in Colorado Revised Statutes Title 38, Article 12, along with recent legislative amendments that have added new requirements. Colorado does not currently have a statewide rent cap that limits the dollar amount or percentage of a rent increase. A landlord can technically raise the rent by any amount, provided they follow proper procedures and the increase isn't motivated by an illegal purpose. However, and this is where Colorado's landscape has shifted dramatically, the state's political trajectory has been clearly moving toward more regulation. Colorado previously had a strong preemption statute that prohibited local governments from enacting rent control. That preemption was repealed in recent legislative sessions, opening the door for municipalities to adopt their own rent regulations. The repeal of the preemption statute was a landmark change in Colorado's housing policy landscape. While the repeal itself didn't impose any specific rent cap, it removed the legal barrier that had prevented cities from acting independently. This means that Denver, Boulder, Aurora, Colorado Springs, Fort Collins, and other Colorado municipalities now have the legal authority to enact local rent control or rent stabilization ordinances if they choose to do so. Since the repeal, several Colorado cities have been actively exploring local rent regulation. Denver has been at the forefront of these discussions, with city council members and tenant advocacy organizations pushing for various forms of rent stabilization. Boulder has also been active in the conversation, driven by the city's high housing costs and progressive political culture. Whether any specific city has enacted a local ordinance at the time you're watching this video depends on the current state of local legislation. And this is precisely why Colorado landlords need to monitor local political activity continuously. The Colorado legislature has also continued to consider statewide rent regulation proposals in recent sessions. Bills proposing rent caps tied to the CPI, enhanced notice requirements, and other restrictions have been introduced and debated. While not all proposals have become law, the political momentum is clearly in the direction of more regulation, and landlords should plan accordingly. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Colorado's recent reforms established staggered notice periods based on the tenant's length of occupancy. The landlord must provide at least 21 days' notice for tenancies of less than 1 year, and at least 28 days' notice for tenancies of 1 year or more. These notice periods apply to rent increases as well as other changes to the terms of the tenancy. So, if a tenant has been in the unit for 2 years, rent is due on the 1st, and you want the increase to take effect on May 1st, you need to deliver the notice at least 28 days before May 1st, by approximately April 3rd. For a tenant who has been there less than a year, the notice must be delivered at least 21 days before the effective date. The notice must be in writing and should clearly state the current rent, the new rent amount, and the effective date. Colorado's recent reforms have added transparency requirements, and the notice should include sufficient information for the tenant to understand the change. Deliver by a documented method, personal delivery, posting on the premises and mailing, or other methods specified in the statute or lease. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. At renewal, the landlord must provide the applicable notice of any proposed increase, 21 or 28 days, depending on tenancy length. When the lease approaches expiration, the landlord should make pricing decisions and deliver notice well in advance. For week-to-week tenancies, Colorado requires at least 3 days' notice before rent changes take effect. Now let's cover the restrictions. and Colorado has been adding them at a rapid pace. Rent increases cannot be retaliatory. Colorado has strengthened its anti-retaliation protections through recent legislation. Landlords cannot raise rent in retaliation for a tenant exercising any legal right, including making a repair request, filing a habitability complaint, reporting code violations, contacting a government agency, organizing with other tenants, and exercising any right under the landlord-tenant statute. Colorado's expanded anti-retaliation provisions create a presumption of retaliation if the landlord takes adverse action within a specified period after the tenant's protected activity. The landlord must then demonstrate that the increase was motivated by legitimate business factors unrelated to the tenant's complaint. Given Colorado's recent strengthening of these protections, landlords should be particularly careful about the timing of rent increases relative to tenant complaints. The consequences of a retaliatory rent increase in Colorado include liability for actual damages, statutory penalties, and attorney's fees. The recent legislative reforms have enhanced the remedies available to tenants, making retaliatory conduct increasingly costly for landlords. Colorado's just cause eviction protections also interact with rent increases. Because landlords cannot terminate a tenancy without cause for tenants who have been in the unit beyond a specified period, a massive rent increase designed to force a tenant out, rather than reflecting a genuine market adjustment, could be challenged as a constructive eviction or as a violation of the just cause framework. While there's no specific statutory provision directly addressing this intersection, Colorado's tenant-protective political environment and judicial attitudes suggest that courts would scrutinize rent increases that appear designed to circumvent just cause protections. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Colorado Anti-Discrimination Act, found in Colorado Revised Statutes, Title 24, Article 34, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity or expression, disability, familial status, marital status, ancestry, creed, or source of income. Colorado's anti-discrimination protections are among the broadest in the country. The source of income protection is particularly significant for rent increases. A landlord cannot raise rent specifically to push out a tenant who receives housing choice vouchers, Social Security disability, veterans benefits, or other lawful income sources. A rent increase that appears targeted at subsidy recipients, while other comparable tenants are not similarly affected, can result in a discrimination complaint with the Colorado Civil Rights Division. The Colorado Civil Rights Division investigates fair housing complaints and can take enforcement action, including ordering damages, injunctive relief, and civil penalties. Colorado's broad protections and active enforcement create substantial liability exposure for discriminatory rent increases. From a practical standpoint, Colorado's rental market is one of the most dynamic in the Mountain West, with significant variation between the Front Range metropolitan areas and the rest of the state. Denver is the epicenter of Colorado's rental market and one of the most active markets in the country. The city's economy is driven by technology, healthcare, aerospace and defense, energy, financial services, and a vibrant, creative economy. Denver has experienced extraordinary population growth over the past decade, driven by lifestyle migration. People drawn to the city's outdoor recreation access, cultural amenities, and quality of life, along with corporate relocations and job creation. Denver's rental market saw dramatic rent increases during the peak growth period, with some neighborhoods experiencing double-digit annual increases. The market has moderated somewhat as significant new apartment construction has added supply, but rents remain high by national standards. Capitol Hill, Rhino, Lodo, Highland, and Cherry Creek are among the highest rent neighborhoods. The suburbs, including Aurora, Lakewood, Westminster, and Thornton, offer more moderate pricing but have also seen substantial increases. Denver is also the most likely Colorado city to enact local rent regulation given the repeal of the state preemption. Landlords in Denver should be particularly attentive to city council activity around housing affordability and rent regulation proposals. Boulder has one of the most expensive rental markets in Colorado, driven by the University of Colorado, the technology sector, including a concentration of federal research labs like NIST and NOAA, and the city's desirable lifestyle. Boulder's geographic constraints, the city is bounded by open space on multiple sides, limit new construction and keep supply tight. Rents in Boulder are among the highest in the state, and the city's progressive political culture makes it another strong candidate for local rent regulation. Colorado Springs has experienced significant growth driven by the military, including Fort Carson, Peterson Space Force Base, Shriver Space Force Base, the Air Force Academy, and NORAD, along with healthcare, technology, and the outdoor recreation industry. The rental market has tightened considerably, and rents have increased substantially. Military tenants' housing budgets are tied to BAH rates, and the large military population makes BAH rate monitoring essential for Colorado Springs landlords. Fort Collins, home to Colorado State University, has a rental market influenced by the university, technology, craft brewing, and lifestyle migration. The market is competitive, and rents have increased. Student housing near CSU follows the academic calendar. The mountain resort communities, including Vail, Aspen, Breckenridge, Steamboat Springs, and Telluride, have extraordinarily expensive rental markets driven by tourism, recreation, and second home ownership. Seasonal worker housing is chronically scarce, and year-round residents face extreme affordability challenges. Some mountain communities have been among the most active in exploring local housing solutions, including potential rent regulation, workforce housing requirements, and other measures. The Western Slope communities, including Grand Junction and Durango, have more moderate markets influenced by energy, agriculture, tourism, and regional healthcare. Eastern Plains communities have softer markets tied to agricultural economics. Pueblo has a more affordable rental market that has seen growth as the Front Range's rising costs have pushed some residents southward. The cannabis industry, steel manufacturing, and healthcare drive the local economy. One critical best practice for Colorado landlords: monitor both state and local legislative activity continuously. Colorado's regulatory landscape has been changing rapidly, and new requirements can be enacted at both the state and municipal level. Join a local landlord or apartment association that tracks legislative developments, subscribe to updates from the Colorado General Assembly, and monitor city council agendas in every jurisdiction where you own property. Being caught off guard by a new regulation can be costly. Another best practice: document the business justification for every rent increase meticulously. Given Colorado's strengthened anti-retaliation protections, expanded anti-discrimination categories, and the political environment that scrutinizes landlord conduct, having clear documentation that supports each increase is essential. Keep records of market comparables, operating cost changes, including the property tax increases that have accompanied rising property values along the Front Range, insurance premium changes, and capital improvements. For landlords in the Denver market, be aware that significant new apartment construction has added supply in recent years. While demand remains strong, the additional inventory has given tenants more options and has moderated the extreme rent growth of the peak period. Pricing your units competitively relative to both existing and new construction, considering location, unit condition, amenities, and transit access, produces better results than simply pushing for the highest possible rate. For landlords in mountain resort communities, the seasonal dynamics require a different pricing approach. Year-round tenants provide stability but may require more moderate pricing to retain. Seasonal workers accept higher rents but create turnover. The chronic workforce housing shortage in resort communities has driven some municipalities to explore local housing programs and potential rent regulations. Landlords in these communities should be particularly attuned to local political activity. Colorado has specific provisions regarding marijuana use that can interact with rent increases. While recreational marijuana is legal in Colorado, landlords can prohibit its use on their property through lease provisions. This is a lease management issue rather than a rent increase issue, but landlords should ensure that their leases clearly address marijuana policies. Colorado also has specific requirements for manufactured home community lot rents under the Colorado Mobile Home Park Act, Title 38, Article 12, Part 2. Landlords who own or manage manufactured home parks must follow specific notice and procedural requirements for lot rent increases, including providing detailed written notice and, in some cases, meeting with residents to discuss proposed increases. For Colorado landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. Given Colorado's source of income protections, the interaction between voucher rules and anti-discrimination law is important. Submit increase requests well in advance. Colorado requires landlords to return the security deposit within 1 month of the tenant vacating, or up to 60 days if the lease specifies the longer period. The landlord must provide an itemized statement of deductions. If the landlord fails to comply, they may be liable for treble the amount wrongfully withheld, plus attorney's fees. Colorado's treble damages provision for deposit violations makes compliance essential. While these rules don't directly regulate rent increases, Colorado's strong penalty framework reinforces the importance of following all procedural requirements carefully. For the complete guide to Colorado rent increase laws, visit tenantscreeningbackgroundcheck.com. And subscribe to our channel so you stay compliant in every state.